Right now, thousands of people preparing to move to Australia are still relying on information that is no longer current. And these are not just minor updates or technical adjustments. We are talking about major changes to visa policies, salary requirements, migration priorities, entry powers, and the broader skilled migration system that could dramatically affect your chances of securing an Australian visa. For some applicants, missing these updates could mean delays lasting months. For others, it could lead to extra costs, lost opportunities, or even visa refusals that might have been avoided with the right preparation. So, if living, studying, or working in Australia is part of your future plan, what is happening right now inside Australia's immigration system is something you need to understand clearly. Because over the coming months, Australia is rolling out one of the most significant immigration restructures seen in years, and many applicants are still unaware of how quickly the system is changing. If you want to stay ahead of these updates, make sure you subscribe and turn on notifications. We cover major immigration changes as they happen, so you can stay informed before new rules catch applicants off guard. Now, let me explain why this matters so much right now. We are already in May 2026, and several of these immigration changes are either already active or scheduled to begin within the next few weeks. If you have not been paying close attention to these updates, there is a very real chance you are already working with outdated information. So let's go step by step through the biggest immigration changes you need to know about right now. And the first one is arguably the most controversial. In March 2026, the Australian Parliament passed a new law known as the Migration Amendment Act 2026, officially titled the Migration Amendment Measures No. 1 Act 2026. This legislation introduces powers that Australia's immigration system has never previously had. Under the new law, the immigration minister now has the authority to impose what are known as arrival control determinations. In simple terms, this means the government can temporarily stop certain groups of visa holders from entering Australia, even if those individuals already hold valid visas. And importantly, this is not the same as a visa cancellation. Your visa may technically remain valid, but if your visa category or region becomes subject to one of these determinations, you may still be prevented from boarding a flight to Australia until the restriction is lifted. The government says these powers are designed to respond quickly during periods of elevated migration crises, international crises, or sudden border management concerns. But critics argue the law gives the minister extraordinarily broad discretionary powers, with very limited transparency or review mechanisms. And for visa holders offshore, especially temporary visa holders, this creates a new level of uncertainty that did not previously exist in Australia's migration system. For the first time in Australia's migration history, the government now has the power to temporarily block certain groups of temporary visa holders from entering the country even if those individuals already hold valid visas. And that is a major shift in how Australia manages immigration and border control. Think about what this means in practical terms. You could go through the entire visa process, receive approval, pay all the required fees, organize your travel plans, and even book your flight, only to discover that you are unable to board because the government has activated what is known as an arrival control determination affix, affecting your visa category or region. Under the legislation, each restriction can remain in place for up to 6 months, and importantly, those restrictions can also be extended or renewed. What makes this especially significant is that the visa itself is not technically canceled. Instead, it is effectively placed into a temporary suspension period while the restriction remains active. Once the restriction is lifted, the visa becomes usable again. But until that happens, affected visa holders outside Australia may find themselves unable to enter the country, despite already having lawful approval. The government has stated that permanent residents, immediate family members of Australian citizens, and humanitarian visa holders are protected from these measures. However, many temporary visa holders are not protected under the new framework. That includes categories such as student visa holders, skilled temporary workers, visitor visa holders, certain sponsored visa applicants. And this is not just hypothetical legislation sitting unused on paper. Australia already applied travel restrictions affecting certain Iranian visitor visa holders earlier in 2026, giving people a first real example of how these powers can operate in practice. Whether people support or oppose the policy, one thing is very clear. This represents a completely new era in Australian immigration management, especially for temporary migrants who are offshore. Now, let's move to the second major change, and this one directly affects employer-sponsored skilled migration across Australia. The second major change affects almost everyone pursuing an employer-sponsored skilled visa in Australia. Starting from July 1st, 2026, Australia is officially increasing the minimum salary thresholds for employer-sponsored migration pathways. The core skills income threshold, which applies to visas such as the subclass 482 Skills in Demand visa and the subclass 186 Employer Nomination Scheme, will increase from 76,515 Australian dollars to 79,499 Australian dollars per year. At the same time, the specialist skills threshold will rise from 141,210 Australian dollars to 146,717 Australian dollars annually. That represents an increase of nearly 4%, and importantly, this change happens automatically from July 1st. No additional legislation is required. Now, here is the part many applicants and employers are only just starting to realize. If your employer sponsorship or nomination is being prepared now, but the application is lodged after July 1st, the salary offered must meet the new threshold, not the old one. And if the salary falls below the updated requirement, the nomination can be refused outright. That means some applicants who believed they already met the requirements may suddenly find themselves below the new salary line once the updated thresholds take effect. As a result, many employers and sponsored workers are currently rushing to either lodge applications before the July deadline, renegotiate salary packages, or adjust employment contracts to remain compliant. So if you currently have a sponsorship application in progress, this is something you should review urgently with your employer or registered migration agent to make sure your timeline and salary arrangement still satisfy the upcoming requirements. Now operates across 3 distinct streams. There is the specialist skills stream for high-income earners, the core skills stream for occupations on the Consolidated Skilled Occupation List, and the essential skills stream, which is designed to capture critical lower-wage roles. This restructuring changes which occupations qualify, what income levels are required, and how employers must nominate workers. If you are in healthcare, construction, electrical trades, or technology, there is genuinely good news here. The government is fast-tracking skills assessments and accelerating access for up to 4,000 additional skilled trades workers per year. But if your occupation does not appear on the updated occupation list, your pathway may be significantly narrowed. Do not assume your old application strategy still works. The rules have changed. The fourth announcement comes straight from the 2026 federal budget, delivered on the 12th of May, 2026. The government has confirmed the permanent migration cap stays at 185,000 places for the coming year, with roughly 70% going to skilled migrants and 30% to family migrants. But here is the important shift. Of those 185,000 places, the majority are now being allocated to onshore applicants, meaning people already living in Australia. Specifically, 129,590 places out of the total have been reserved for those already on the ground. Only 55,110 places remain for offshore applicants, those applying from outside Australia. This is a significant change for anyone sitting overseas waiting to get in. The competition for offshore spots is now fiercer than ever, and the government has made it very clear that it is prioritizing people already contributing to the Australian economy. If you are offshore and planning a skilled migration pathway, you need to seriously reconsider your strategy and timeline. The fifth announcement relates to students and the international education pathway. There is some positive news here. The student visa planning level has increased to 295,000 places for 2026, up from 270,000 in 2025. However, the pathway from student visa to permanent residency has become significantly harder. There is now a genuine student requirement that adds scrutiny to every application, and the minimum overall IELTS score required has been raised to 6.5, with no individual band falling below 5.5. On top of that, work experience points now require direct verification from employers on company letterhead. Students who assume that studying in Australia would smoothly lead to permanent residency are finding that the goalposts have moved considerably. If you are a student or planning to become one, please understand that admission is getting easier in terms of numbers, but the route to staying permanently is getting harder. The sixth change is one that is quietly affecting a huge number of people: processing times. This is not a policy announcement, but it is one of the most important realities of Australian immigration right now. The subclass 482 core skill stream is taking up to 7 months for processing. The subclass 186 permanent residence pathway is taking up to 20 months. Some training visas are taking over a year. 3 Australian immigration offices in Washington, Dubai, and Singapore have been closed, which is adding further pressure to processing pipelines. What this means practically is that if you are planning to lodge a visa and expecting a quick decision, you need to build significant extra time into your planning. People who applied thinking they would have a visa in 3 months are sitting at the 6 or 7 month mark with no outcome. If you have a job start date, a family situation, or a lease arrangement tied to your visa approval, this delay can be financially and personally devastating. The seventh and final major announcement is about the Working Holiday Maker program. The government has confirmed it is expanding the use of ballots to manage working holiday maker numbers. This means the days of simply applying and getting a working holiday visa are moving toward a lottery-based system for certain nationalities. The government has described this as creating a fairer allocation of places. But in practice, it means you can no longer take it for granted that your application will be approved just because you meet the eligibility criteria. If you were planning a working holiday in Australia, especially coming from countries that have traditionally had high application volumes, you need to check the current ballot status for your nationality and plan accordingly. So let us bring all of this together. What should you actually do right now? First, check whether your occupation is on the updated Consolidated Skilled Occupation List at me.gov.au. Second, if you have an employer sponsorship in progress, check whether your salary meets the new July 1st thresholds, and get your nomination in before the deadline if it does not. Third, if you are an international student, make sure your IELTS score meets the new minimum of 6.5 across all bands. Fourth, if you are offshore and planning a skilled migration pathway, speak to a registered migration agent immediately about the new offshore allocation reality. Fifth, build extended processing times into every single plan you make. Do not assume faster processing means guaranteed approval. And most importantly, make sure you are following reliable and up-to-date sources, because Australia's immigration system is changing rapidly, and relying on outdated information can genuinely damage your application or delay your plans significantly. Australia remains one of the world's most attractive destinations for skilled professionals, international students, and families seeking long-term opportunities and stability. But the migration system in 2026 is more competitive, more strategic, and far more dynamic than it was just a few years ago. Success is no longer only about meeting the minimum requirements. Increasingly, success comes down to preparation, timing, strategy, and understanding how the system is evolving in real time. The applicants who succeed are often not simply the most qualified on paper. They are the people who stay informed, adapt quickly, and make decisions based on current policy rather than outdated assumptions. You now understand changes that many applicants still do not fully realize are already happening. Use that knowledge carefully and strategically. And if you know someone planning to study, work, or migrate to Australia, share this information with them, because these updates could directly affect their future plans. Stay connected for future updates as Australia's immigration system continues to evolve throughout 2026.